Swayam Prabha. Digital India. Educated India.
Namaskar, dear students. I am going to take 11th lecture on Transfer of Property Act. Today I will discuss sale of immovable property. It is one of the important chapter within the transfer of immovable property. Okay. Myself, Dr. Amarendra Kumar Ajit, Assistant Professor, Faculty of Law, University of Delhi. So let's start a new chapter, new module in Transfer of Property Act, that is sale of immovable property. So first of all, sale may be of immovable as well as movable property. But when we talk about Transfer of Property Acts, so it mainly governs the transfer of immovable property, and within that we are going to see the sale of immovable property. For the sale of movable property, there is a Sales of Goods Act, and that governs the movable property sale, whereas TPA, Transfer of Property Act, governs this immovable property sale. Then this is the most common type of transfer of immovable property, which is generally used in is as compared to lease, mortgage and other gift. Okay, so sale is one of the important type of transfer which is mainly used under the Transfer of Property Act. Then in maximum cases there is a requirement of a registration. Okay, and whatever the provision has been given for the non-registration or optional has been kept, that is now these days it is irrelevant. So I am saying that in most of the cases, 99.9% cases, registration is necessary. So section 54 deals with the definition of sale. According to section 54, sale means it is a kind of transfer of ownership in exchange of a price or promised, paid or promised, or part paid and part promised. Okay. So first of all, I will go through the bare provisions and then I will come to the essential part and introductory part. So within section 54, it is not only defined the sale, but it has been also laid down that sale how made. So it says that the such transfer in case of tangible immovable property of the value of 100 rupees and upwards, or in case of a reversion or other intangible thing, can be made only by a registered instrument. Okay. Then further it says that in case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by registered instrument or by delivery of property. That means just transferring the possession of the property. That means if amount or price of immovable property is less than 100, then registration is optional, and merely by handing over the possession, transfer can be implemented. Then delivery of tangible immovable property takes place when the seller places the buyer or such person as he directs in possession of the property. That means when this delivery used to happen in case of tangible immovable property. One things you might have going through this word tangible immovable property. Okay. So question here is there any intangible immovable property also? Because tangible which we can see, which we can touch, which we can feel. So, these things what we are saying, which is fixed in form, that is immovable property, but there are certain other categories, mainly I will say here, like intellectual property, that falls under intangible immovable property. Okay. So, here it is when delivery of tangible movable property take place when the seller places the buyers that position to whom he is going to sell. And last part of the bare provision is contract for sale. So, contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between parties. It does not of itself create any interest in or change on such property. So, now I am going to elaborate one by one all these contents and provisions. So, first of all, sale itself. According to section 54, what is sale? Okay. So, sale is a kind of transfer first of all, because we are reading transfer of property act. So, this transfer here in case of sale is of immovable property, and it is the transfer of ownership, because transfer of immovable property may be of different types, but here ownership must be transferred. That is important part of sale, and in lieu of what? In lieu of money consideration. So, money is very important. Okay. Money plus change of ownership is main essential, we can say, under section 54 main definition. Then it says that it is an absolute transfer of all rights in the property sold. Why this is important? Because ownership, when there will be transfer of ownership, that means all rights related to that property is going to be transferred to the purchaser. So, nothing will be left or nothing will remain in the hand of seller for subsequent thing or subsequent time. Okay. So, it is a complete transfer of rights to the purchaser. So, it is absolute transfer of all rights in the property sold. So, he cannot keep any kind of condition within that. Okay. Then no right in property sold are left in the transferor, so distinguished from the mortgage, lease, okay, in that way. That means, in case of mortgage and lease, even though property is transferred, but the rights of ownership is not transferred. Property possession will be transferred, but the right always remain, and certain rights related to that immovable property always remain with the owner. So, in that case ownership is not transferred in the case of mortgage and lease. So, it is different kind of things, and from childhood itself we are used to know that what is sale, whether it is for movable or immovable. So, sale means it is a kind of complete transfer of the property. So, in once we try to analyze the concept of ownership, that what is ownership. So, the basic and fundamental concept of ownership generally we used to read in the jurisprudence paper, but the concept of ownership is like that it is a bundle of rights. Bundle of right, that means rights related to property in the hand of the owner. Okay. So, all kinds of right related to that property will be in the hand of owner. So, just like it is a enjoyment right, enjoy in the various way, sale right, disposing right. So, there are number of rights related to immovable property with the owner. So, if you will go through the most popular definition of ownership, that is given by John Austin. He said that ownership refers to a right indefinite in point of user, a right indefinite in point of, that means there is no time limit of ownership. Okay. That means even after the death the ownership is transferred to the legal heirs. So, it is indefinite in time, then unrestricted in point of disposition. That means, no one is going to tell or say that when your right is going to end, it is your discretion. That means, it is the owner's discretion that when he is going to dispose of the property or he is not going to dispose of the property. Okay. So, it is unrestricted in point of disposition and unlimited in point of duration. So, there is no timeline, there is no restriction on disposition, and it is a indefinite in point of user. So, this is these are called as the essential of ownership. So, when you go through the ownership, then this right to possess, right to own, right to dispose of, all these are the rights of owner. So, ownership property, that means here in case of sale, ownership with respect to immovable property is transferred in exchange of money. So, money is main matter here. If something has been transferred in lieu of other than money, then this is not a sale. Okay. That means, it will fall under the category of exchange, what we used to know in the case of movable property as a barter system. Okay. So, here in case of immovable property, if you are going to purchase something after giving another thing, that means not money, the consideration will be other than money, then it will be called as exchange. Whereas, there is transfer of ownership without money, then it go under the category of gift. So, in case of sale, money is a very important part. That means, whatever it is going to be transferred, that will be transferred, that immovable property transfer with exchange of money only. Okay. So, that is important. So, transfer of ownership only for money consideration, it has been written, it is a only for money consideration is known as sale. Otherwise, it will fall under the category of gift, it may fall under the category of exchange, but it will not fall under the category of sale itself. Then, generally we see 4 essential of any sale, and within that 4 essential, first is party, second is subject matter, third is money consideration, and fourth is conveyance. Okay, PSMC. So, I am going to discuss one by one about the parties, about the subject matter, money consideration, conveyance, and in between I will discuss certain legal decision of the high courts and supreme courts on these points. So, first come to the parties. So, sale is also a kind of contract. So, whatever the contract act conditions apply in any kind of contract, that will apply here also. So, first of all, in any contract there is a requirement of 2 parties, that is in case of sale it will be seller and purchaser, vendor or vendee, transferor or transferee. Okay. So, seller is a person who transfer the property is known as transferor, seller or vendor. Purchaser is the person who purchased the property and known as transferee, purchaser and or vendee. Then the most important criteria of any contract is competency. That means party must be competent to contract. Okay, party must be competent means mainly it is the party must be major as well as party must be sound mind. Okay. So, whoever, that is whether it is a purchaser or seller, in both the case it has been said that the major and sound mind and must own the property. That means, they must own the property, that means they must be the owner of any immovable property, then only he can transfer or she can transfer. Okay. So, ownership of properties must be competent, must be major, and it has been said that less than ownership cannot be transferred, less than ownership cannot be transferred. So, it is always absolute transfer. I have discussed already earlier, it is always absolute transfer. Okay. So, not less than ownership can be transferred. So, all rights related to ownership will be transferred to the purchaser. Then there are certain restriction statutory provisions also, that in some cases there will be according to the law itself, purchaser are disqualified. Okay. Purchaser must not be disqualified in law, and the best example is section 136 of TPA itself, Transfer of Property Act, which says that a judge or legal practitioner or an official of the court is incompetent to purchase actionable claim. That means, because they are defending the rights of the litigant. So, this is a provision which is based on public policy. That means, you are you are advocate for a client and immovable properties are the subject matter of dispute, then advocate or judge who are dealing with that, they should not purchase the property from the client. Okay. So, they are not entitled under TPA. So, parties may be natural as well as legal person. So, any human being may be, any company may be, even partnership firm. Okay. So, even any NGO, so they can purchase property. Then next important point within the parties itself is intention, intention of transfer. That means, if seller is not willing to transfer, then transfer will not happen. Okay. So, intention is very important part, that intention is main, I will say that even though there is seems like a transfer, but if there was no intention on the part of the seller, then it will not amounted as transfer. So, the Supreme Court has emphasized this point, okay, and said that the execution and registration of sale deed are mechanical acts. Execution and registration both are a kind of mechanical act, okay, and therefore not sufficient in themselves for passing title and ownership. That means, execution deed itself and registration is not sufficient if there was no intention to transfer. Okay. So, take the example in this case, that means under coercion all execution and registration has done by force. Okay. Then can you say that it was a proper transfer? Because there was no intention to transfer that property. So, in that way it is very clear, unless and until there is no such kind of intention on the part of the seller, then it will not result into transfer. So, all this, but how you will find the intention? Okay, that whether there was an intention on the part of the seller or not, or so it has been said that all this must be done with the intention of transferring title. The intention of the parties has to be a certain, such intention has to be gathered from the recitals of the sale deed. Okay, that why he wanted to transfer, what was the reason for transfer, and whether there was a free will of the transfer or not. So, all these things may be reflected, or if the deed is also not reflecting, then it can be taken from the witnesses and other evidences also, that whether the party was really intended at that time that that property must be transferred. So, this is the case Kalia Perumal versus Rajgopal AIR 2009 Supreme Court 1222. Then sale through power of attorney. This is also very important part within the sale itself, that if sale is happening through power of attorney, then what is the fate of that, and to what extent it will be acceptable, that whether it is a sale or not. Okay. So, it has been said that the documents like an agreement to sell, a general power of attorney and a special power of attorney do not amount to sell. Do not amount to sell. What is, it should not be confused that the general power of attorney itself is not a sale. General power of attorney is given to execute the sale, but itself is not a sale. Okay. So, in that case what happens, that court has said, Punjab and Haryana High Court in Harmesh Kumar versus Mayabai, that a transaction may be void if fraudulently done with the power of attorney. That means, if the power of attorney, okay, was fraudulently taken, in that case it will be void ab initio. Plaintiffs, in this case what was the fact, that the plaintiff husband died and she executed a special attorney, a special power of attorney in favor of her brother-in-law, authorizing him to pursue litigation against her. So, it was a very specific type of power of attorney that she gave that power of attorney to her brother-in-law to represent her in the court. Her intention was to clothe him only with the special power of attorney. Intention was very clear. Intention was to clothe with him only with the special power of attorney. She, being illiterate, unknowingly she executed a general power of attorney. Okay, general power of attorney. The defendant took undue advantage of this fact and fraudulently he alienated her property in favor of his son. Okay, because this power of attorney, general power of attorney, gives power to transfer or power to sell the property, but the general power of attorney itself is not a sell. So, what he did, because intention was not on the part of that lady and she executed a general power of attorney in place of a special power of attorney. So, there was no intention to transfer, there was no intention to give general power of attorney, and fraudulently her brother-in-law misused that power of attorney. Okay. So, court said in this case that plaintiff could produce evidence to show fraud and claim under section 92 clause 1 proviso of section 92 proviso to section 92 Evidence Act 1872 that the sale transaction was void ab initio. So, it is very simple that if there is no intention on the part of the seller, then sale will not happen. Next important point is subject matter, okay, that what is going to be transferred. So, first of all keep in mind that in sale whatever be the subject matter, that will be always immovable property. Okay. And immovable property is defined under the interpretation clause under section 3, and I have already explained under this my lecture number 1 itself when I was discussing the interpretive clause, okay, that what will amount as immovable property. So, immovable property is only the subject matter of sale. Okay. So, immovable property generally includes what? Land and benefit arising out of land and things attached to the earth except standing timber, growing crops and grass, okay, as given under interpretive clause. So, which is in the permanent form, first of all land itself as well as benefit arising out of the land, that is also immovable property. Okay. So, the right to catch and carry away fish is a profit pendere. That means, if any person had right to catch fish from a pond, because pond itself is immovable property and benefit accruing from the pond in the form of catching fish. So, catching right to catch fish itself is immovable property. Okay. So, here it has been said that construed as immovable property. Therefore, an unregistered agreement to catch fish will require registration since the value of property exceeds ₹100. So, if anyone is selling right, just like it is happened in the case of auction and all, that right to catch fish in a particular pond, So, this is a kind of immovable property, cost is more than 100 rupees, then registration will be sine qua non for this property. Okay. So, it was held that settlement of record of the right neither creates nor extinguishes title. Okay. Sudarshan Mandal versus Bhushan Mandal, AIR 2018. Third is money consideration. Okay. Third is money consideration. That means only money should be the part of consideration, nothing else. Whether it has been paid or not, it is immaterial. It may be partly paid, as we have seen in the definition clause itself. It may be partly paid, it may be fully paid, or it may be paid later on. Okay. But it should be money only. So, price is essential element of a sale. Price means value of immovable property and in the form of money. So, price must be ascertained for which the property is going to be transferred. That means, what is the price of immovable property, that must be ascertained before the sale. That means, unambiguity on the part of the deed itself, that means okay, lump sum amount or something which is not very clear, that cannot be happen, but that means price must be ascertained. Then price may be paid at the time of execution of sale or in advance or after the sale. So, that is completely immaterial. Whether the money has been transferred or not, it is not a that condition. Condition is that it must be in the form of money only. Okay. This payment of money may even happen after the sale. Non-payment of sale consideration does not vitiate a sale if it is promised to be paid. It is a very important part. That means, one party has already fulfilled his conditions, that means, he has already delivered possession and all, and the purchaser is saying that I will pay later on. So, it is completely valid. It cannot be said that unless and until it is not going to be paid, then till then sale will be not treated. Okay. So, it is not the case, transaction may happen even after the sale itself. Then uncertain price sale is void ab initio, what I already told you. This uncertain price sale is void ab initio. That means, where there is price is not certain, it is not very clear, in that case it will be not take effect. So, that contract is void completely. Next point is, either a point of way in which it is to be determined or it may stipulate for a fair price. At least there must be some calculation within the agreement itself. That means, what will be the rate of the particular land or property, it is per square feet, okay, or market rate or circle rate, then accordingly we will determine, or we will purchase it accordingly, that according to some formula in the sense that according to the agreement between purchaser and seller, that what is the market rate, over that we will take, or below that what will the discount has been given. Okay. So, that must be taken into consideration, and it must be fixed prior to the execution of the sale deed. Okay. At the time of execution of the sale deed, if it is not clear, then it will go under this uncertain price. Okay. So, that will be void ab initio. Now, question here is there any effect about the amount of consideration on the sale? That means, whether it will be always a market price, or there may be certain kind of discount, or there may be completely exemption from the side of the seller, or minimum amount, minimum that means only a token money can be consideration for a proper sale. So, the rules are very clear on this point. It says that in case of a claim that consideration is paid and found to be incorrect, then transaction does not amount as a sale. That it is a false promise that I have paid, but actually it was not paid, and there are a number of cases on this point. Then inadequacy of consideration is not any relevant factor. inadequacy of consideration is not any relevant factor. This is a general rule, but there are exceptions also. The rule is that there must be consideration, but inadequacy of consideration will not violate the principle that sale deed itself. But there are certain conditions which will reflect that there was not a proper transaction, not a proper consideration. So, when it may be, it says the court may even presume fraud, okay, that consideration must be of some value in eyes of law. Consideration must have some values in eye of law, even though it is inadequate, but there must be some value in eye of law, but it cannot be illusory. Okay. Illusory, that means it should not be in a way that trying to show that it is a sale, but actually it is not a sale, it is a kind of gift. So, that cannot happen. Okay. Here it is that there must be certain consideration which is in law, it may be treated as valuable, inadequate, not inadequate. Inadequate is something different and some value is something different meaning here. Inadequacy may be there. Suppose a property market value is 1000 rupees. So, purchaser is ready to purchase, seller is ready to purchase over the 600 rupees. So, there is a substantial loss on this, but even though it will be a inadequate consideration, but this will have certain value in the eye of law. Okay. Because person may have certain kinds of situation, and in that situation they can sell their property even very below to the market rate. But sometime what's happened, on the same principle, no one can take the advantage that he will sell the property of 1000 rupees within 60 or 70 rupees. Okay. And you might have seen number of cases, specifically in the case of in various cases in political parties or scam cases, where property has been purchased just by giving token money. So, that is not allowed, and that will fall under the different category and it will not go under the sale. So, it may happen in case of quid pro quo cases, where there is a corruption cases, that some party has given a kind of favor to another party and another party has given in a favor of immovable property, and then with mere consideration. Okay. So, this kind of transfer raises certain kinds of doubt in itself, and certainly investigation agency used to go through all those transactions, that actually what has compelled the seller to sell this property on this mere amount. Then the payment of price is not necessary condition for validity of sale. Payment of price is not necessary condition. It can be given even later on. Okay. So, it is not sine qua non for the completion of sale. Sale may happen even without giving consideration prior to the sale. Okay. Sale may not happen without consideration. Consideration is must, but that consideration may be paid later on after the sale. In Samad Baba Narayan Das, Jaman Swami Ram Tirth versus Surta AIR 2002, Punjab and Haryana High Court, mortgager has failed to pay mortgage money, okay, and redeem the suit land. The mortgagee has filed a suit for declaration of ownership after expiry of 60 years. 60 years. Court found that the rate of interest was more than allowed in law, and the plaintiff, that is mortgagee, who has mortgaged the property to the mortgager, had recovered, this plaintiff, that mortgagee had recovered more than the double amount in the amount of the advance. Okay. That mortgagee, the person who took the mortgage. Okay. So, that person has already took amount of money through this up to 60 years, and he has already recovered many times of the given amount. That means, whatever the advance has been given. Okay. So, there was number of times actual amount has been already taken. So, court said in this case that this procedure for the foreclosure was not followed, because he was selling the property. First of all, he took advantage for the 60 years. He has already taken their money, which is given in advance in the form of interest. He has already taken. Then he again want on the name of that about the principal amount, and he was going to sell that. So it has been said that it can't happen. So the court held that the mortgagee enjoyed fruit of lands, and thus the mortgage was deemed to have been redeemed during the period of limitation. The term of the mortgage operated as a clog on the equity of redemption, and therefore the plaintiff was not entitled to any relief in this case. Okay. So this used to happen. Next is, and the last is conveyance, fourth. Okay. This conveyance, that means written agreement, written deed. Okay. So when we talk about the conveyance, so here in 54 it says that there are two modes of the transfer of immovable property. First is by delivery of possession, and second is registration of sale deed. But in the beginning I told you that in 99.9% cases that is the registration of sale deed. Why? Because condition is only of 100 rupees. Okay. So when it has been drafted at that time, there was a value of 100 rupees, 1882 in year 1882. Okay. But in 2024, what is the value of 100 rupees? You cannot get immovable property in 100 rupees. Okay. So all immovable property transfer these days will fall under the category of this registration category. Okay. So here the delivery of possession of immovable property below 100, more or less it is completely in a negligible amount. Mainly it is about the registration of sale deed. So if we talk about the delivery of possession, why I told you already that tangible immovable property of the value 100 rupees and more transfer only by registered deed. 100 or 100 plus amount, if that is the consideration, then there must be registration of the transfer of immovable property. But if it is 99 rupees or below, then it may be done by the mere delivery of possession, or if parties want, then they can register also. So this is the discretion under below 99 or 99 rupees. But in case of 100 or more, that is the compulsion, statutory compulsion is there, there must be registration. Okay. So delivery of property means, what is the meaning of delivery of property? That is also very important part, that in sale when it will be amounted as there is a delivery of property. So delivery take place when the seller puts the buyer in possession of the property. Okay. That means the seller has given the possession of that property to the buyer, then it will be treated as delivery of property. In Mohiddin versus President Municipal Corporation, Khargaon, AIR 1993 MP. In this case, a piece of land was sold for less than rupees 10 with unregistered sale deed. Okay, this is of 1993, and in 1993 a piece of land was sold less than 10 rupees. So no physical possession of property could be proved in this case. Okay. The court held that the transfer of sale could not be proved to have taken place, because there was no physical possession of the property was granted. Where the actual physical possession is not possible to be proved due to the nature or kind of property, then anything done by the seller which amount to a change in possession from seller to the buyer is deemed to be delivery of the possession. That means actual transfer is not possible, then what will, just example here it has been given, that you can say that okay, you can take the key and you just delivery of the key itself will be treated as a kind of possession, or you are saying that you can reside here, okay, that is also a kind of possession. transfer of possession. Or if the buyer is saying that my relative is going to stay there and someone is going to stay, please permit him, in that case also it will be treated as that possession has been transferred. So, by the nature itself, when the purchaser itself is not taking directly himself, or the nature of the property is like that, that it cannot be transferred in that way, then there is possibility that some sign or some indication should be there that there was transfer of possession. Why this is so necessity? This necessary condition is that because it reflects the intention of the party, what I have already discussed earlier, that it is the intention of the party that they really want to deliver or they really want to sell that property, and this is the one medium to reflect that possession has been transferred. Okay. Then registration of sale deed. If your property is of 100 or more than 100 rupees, then registration is must. Transfer can be effected only by registration. There is no option like below 100 rupees. Below 100 rupees you have option, you may go for registration, you may not go for the registration. But 100 or more, there is no such kind of option. Parties are bound to register that transfer. Okay. So, mere making of an agreement of sale or executing of the power of attorney would not transfer the right, title, interest in an immovable property. Okay. Mere making of an agreement of sale, okay, agreement of sale, contract of sale. Okay. So, mere making, because these days this is a practice that before purchasing the immovable property, there is used to be a agreement to sell, that okay, these are the first of all this money, primary money consideration that is called pagadi, and that money and the rest of the amount will be paid. It may be paid in the form of percentage, or it may be paid later on after some time, or within a particular date whole the transaction must be completed. So, this agreement to sale, that okay, purchaser and buyer are ready and they are putting certain term and condition that sales is going to happen in this way, that is called agreement to sell. But that agreement to sell or executing power of attorney would not transfer the right. There is no such kind of transfer of right or ownership by this, okay, in immovable property. It is very clear. So, agreement to sell or agreement for sale, it is not going to transfer any right. It is only that it is a kind of contract, or you can say it is a primary contract which says that how the secondary contract is going to be executed. Secondary contract means contract of sale. So, in Bishundev Narayan Rai versus Anmol Devi, the Supreme Court held that a combined reading of section 8 and 54 of Transfer of Property Act suggests that through the execution and registration of sale deed, because section 8 says about the condition of this execution of sale deed. Through the execution and registration of sale deed, the ownership and all interest in the property pass to the transferee, yet that would be on terms and condition embodied in the deed, indicating the intention of the parties. The intention of the parties can be gathered from the averment in the sale deed itself or by other attending circumstances. So, in that case, it is very clear that in case of agreement to sale or contract of sale, when you are going to execute it, before that if there is certain kinds of this agreement that how you will execute it, then it is not going to transfer any right. Okay. And it also suggests that you were willing to transfer, okay, because it is a primary stage, and within primary stage itself you are saying that okay, these are the condition for the transfer. So, it is reflecting the intention of the seller, that seller want to transfer and buyers want to buy, okay, and accordingly they will execute the whole agreement of sale. Then Registration is a prima facie proof of intention of seller. Registration is a prima facie proof of intention of seller. That means seller has did it, seller was willing to sell it, there was intention to sell this property, because on that both are going to sign, that is seller as well as buyer. Okay. So, that the wanted to transfer the ownership on the date of execution. But here one question is you may ask, whether it is only the intention of seller is important or intention of buyer is also important. Okay. So, keep in mind here that intention of seller is important. Why intention of seller is important? Because seller is going to execute, seller is going to transfer his property. So, who is going to lose right? The right is going to be alienated or right is going to be lost in the form of transfer itself over that property by the seller, not by the buyer. Buyer is anyway, he is the gainer, okay, through the consideration or by any other means, if in case of other kind of transfer. But when we are talking about the sale, within the sale itself, buyer is the gainer of the property and he will get rights over those property, but this seller is going to lose his right over that property because he is trying to sell that. If there was no intention and some fraud has been committed, okay, so who will lose that? It will be the part of the seller, not the buyer. So, buyer intention is the seller intention is important, not the buyer. Seller important is seller intention is very important, because he wanted to sell it, then only it will be a valid sale. But where the some condition is laid down in the deed itself, that the title shall not pass on the purchaser till the condition in the deed is fulfilled, then it is a valid one. Okay. Where an immovable or movable property are sold to a single consideration, that means both are combined together. That means in a single transaction, movable and immovable things are sold. Okay. Then the sale is in effect both for movable as well as immovable property, because the document embodies only one transaction and there is no separate transaction for movable property. So, that will be treated as a sale for the both movable or immovable, because sometime when we used to sell the real estate, okay, so within that you might have read in the lecture 1 and lecture 3 that there are some fixings which may fall under the category of movable property, but there are some fixture which will fall under the category of immovable property. But once you are selling the flat, building and all, at that time movable and immovable both are going in the same document. So, here it has been said that both that through that deed only the movable will be also treated as that it has been sold. For there that means for those movable goods there is no requirement to again create a deed under the Sales of Goods Act. It will happen only within the Transfer of Property Act itself. Then mere presence of the plaintiff, mere presence of the plaintiff at the time of drafting or writing is not sufficient to prove that he knew the contents of the document. Okay. He knew the contents of the document. Why? That means here first intention is very important. Someone has been drafted certain kind of document of deed of sale, but it was not readable and he was the person who is selling, that person is illiterate. So, he will not know about the term and condition within that. So, only mere standing will not give a kind of impression that there was a consent on the part of the seller. So, no presumption of undue influence can arise, no presumption of undue influence can arise, because parties are related to each other and executant is old or of weak character. Okay. Because undue influence is also very important, there should not be any undue influence at the time of decision making. Okay. So, here it is saying that if the parties are known to each other, or parties is very old, or party has a weak character, all these things are not going to determine that there was no free will. Okay. It was held by the Supreme Court that the court must scrutinize pleadings to find out exercise of undue influence. Okay. whether there was undue influence or not, there must be through different witnesses, evidences, it must be gathered, because once you are going to take the defense of undue influence, that there was certain kinds of coercion, misrepresentation, all, okay. That means there was no free consent, there was no intention to sell, then court will go beyond the sale deed. Then one example is I have mentioned here, that is Jagannath versus Jagdish Rai AIR 1998 Supreme Court 2028. In this case, what was happened, this example has been given in the Mullah book of Transfer of Property Act, that a person entered into an agreement to sell a immovable property to another person P1. In between, when he was, that means there was an agreement to sell, that I will sell the property to P1. I have not sold to the P1, but again I made an agreement with the P2 subsequently. The owner entered into another agreement to sell the same property to P2. The subsequent purchaser was a bona fide purchaser without knowing that the owner has made an agreement with P1. Okay. So, the court held that the P1 with whom the owner has made first agreement to sale or agreement of sale would not be entitled to relief under a specific performance against subsequent purchaser, okay, because he was the bona fide purchaser. So, that is not possible. Then cancellation of sale deed. This is also important, that whether person who has executed this sale deed, can he cancel his sale deed or not. Okay. So, and when he can cancel. So, a transfer by way of sale which was affected by the registered deed of the transfer. Okay, that means everything has been done, possession has been transferred, this sale deed has been executed and registered. Then after he wants that I am going to cancel the sale deed. So, court said that it became an absolute transfer from the vendor to the purchaser. Already everything has been done and absolute ownership has been transferred. The vendor became divested of this ownership. He retained no control or right over the property. Such transfer could not be annulled as cancelled unilaterally by the vendor by executing a deed of cancellation. So, it is not possible that now the seller will cancel the sale deed and he will say that okay, I do not want to sell it. It can't happen. Once this sale has been done, then it has been done. Such a deed cannot be accepted for registration. Okay. That cancellation of sale deed cannot be accepted for registration. Already registration has been done for the sale deed. Cancellation of sale deed cannot be registered. Cancellation of sale deed can be ordered only under section 31 of the Specific Relief Act. Okay. That means he will have to prove certain grounds under the specific relief that why that sale deed should be cancelled. Otherwise, it is not possible to cancel the sale deed. Okay. So, Latif Estate Line India Limited versus Hadiza Ammal AIR 2011 Madras. Okay. So, this cancellation of sale deed. Then further it says that if a transferor want to cancel the sale deed subsequent to the registration, he has to file a civil suit for cancellation under a Specific Relief Act, or alternatively he can buy back the property from the transferee. There are two options, either to file under the Specific Relief Act in civil court, proper suit, civil suit, or purchase the property from the buyer. So, second option is very difficult. If the buyer is not ready to sell again, then only one option will be left, that is go to the civil suit, and there should be a proper condition for that. He cannot execute a cancellation deed unilaterally, nor can he have it registered it. He cannot unilaterally declare it, this sale deed, and he cannot register also that cancellation of sale deed. So, it is very clear on that. Next is contract of sale. Okay. The question arises that does the contract of sale of immovable property gives any right in the property to purchaser. Okay. So, the section says that the contract of sale does not itself create any interest in or charge on such property. Contract of sale is that, okay, you are going to purchase the property, we will purchase it, but it will not create any kind of right. But English law is different from this. English law says that in case of contract for sale, transfers an equitable estate to the purchaser. Okay, but in India this is not the case. Equitable estate, that means now the purchaser will also get certain claim under that property, but this is not in the case of India. In India, it may be said that the contract for sale is merely a document creating a right to obtain another document that is duly executed sale deed. Okay. So, one agreement to get the complete the another agreement, not more than that. A person who enters into contract of sale does not become entitled to any interest in land for sale or of which the contract was made. So, rights will be completely zero. The rights is only his that sale deed should be executed according to the agreement of sale, nothing else. On property there will be no right at all. So, what is the difference between sale and contract of sale? So, sale is the transfer of ownership, whereas contract for sale is merely an agreement. Sale is, in case of sale, all rights and liabilities are divested, that is, it will go from the owner to the purchaser, seller to the purchaser. In case of contract of sale, there is no divesting of any kind of interest. Then, in case of sale, there is convey a legal title to the purchaser. In case of contract for sale, there is no change in the legal title of the purchaser. Then, in case of sale, it creates right in rem. In case of contract of sale, it creates rights in personam. Personam means against that person only to whom I have signed an agreement. But in case of transfer of property, immovable property, it will create a right in rem, because if I have purchased something, then no one will have a right against this property except me. Okay. So, I will reside over this property, I can make house, no one can make. So, it is a right against whole world, but in case of contract of sale, I will have only right to that person against those who has seller against seller who is selling it, nothing else. So, sale requires a compulsory registration, whereas contract for sale does not require any registration. So, this is the main difference between contract of sale and contract for sale. So, it is the end of the sale itself. Okay. So, in next lecture we will meet on the rights and obligation of buyer and seller. Thank you.